Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 9 and 10 on the speed of 90 words per minute. Start. In the present case, the learned single judge has held that in view of the circular which has been issued by the Director of Education on 4 August 2003, any amendment in the scheme of administration of the institution for extending the term by 2 years would be applicable to the term of office of the newly elected committee of management after the election is held on a date subsequent to the date on which the proposal for extending the term of office is accepted by the Joint Director of Education. The Director of Education had in fact, in the present case, clarified by a communication dated 3 December 2012 that the enhancement of the term of the Committee of Management from 3 years to 5 years will not ensure to the benefit of the existing Committee of Management which has been elected before the resolution for the enhancement of the term has been passed and would apply to the Committee of Management which would be constituted after the elections were held afresh. On behalf of the appellants, it has been submitted that the learned single judge, while taking note of the judgment of the full bench and of the earlier decision of the division bench in Committee of Management, Arya Kanya Inter College Supra, has lost sight of the fact that in the case before the division bench, the approval which was granted by the Joint Director of Education contained a specific provision to the effect that the benefit of the extended term will entail to the Committee of Management of which elections were held subsequent to the date of approval. In the present case, it was submitted that the Joint Director of Education, while approving the amendment, did not impose any such stipulation and hence the enhancement of the term must also ensure to the benefit of the existing Committee of Management. It is not possible to accept the submission for more than one reason. Firstly, as the judgment of the full bench now holds, if the approving authority has the power in law to lay down a stipulation that an amendment shall be effective from a future date, then the amendment would apply in accordance with the condition or stipulation laid down by the approving authority. In the absence of any such special feature or stipulation, the amendment shall apply to the Committee of Management existing on the date on which the amendment comes into force. Applying this observation in the context of the UP Intermediate Education Act 1921. It is clear that subsection 5 of section 16A of the Act requires the prior approval of the director to every amendment or change in the scheme of administration. Since the director is vested with a statutory power to grant or refuse his prior approval, incidental to the exercise of power, it is open to the director to stipulate that the approval shall not ensure to the body which has proposed by a resolution the enhancement of the term. Now, coming to the second question, I am of the view that the appointment made on a post which is not in accordance with law would not confer any right upon the incumbent either to hold the post or to continue in service on such post in any manner. Mere length of service or lack of any fault on the part of the employee concerned is not relevant in as much it is the observance of statutory provisions and not the personal or individual act on the part of the parties concerned which would decide the rights of the persons to hold the post. If a person does not possess the requisite qualification or is otherwise appointed on a particular post in violation of the statute, he or she cannot claim to have a right to continue in service simply because it has worked for a long time, for the reason that estoppel does not apply against statute and any appointment against the statute is void ab initio. Even on the ground of sympathy, no such relief can be granted since a court of law is primarily concerned with rule of law consistent with constitutional provision and mere sympathy, which is directly against the statute and constitutional provisions, would be a case of misapplication of the understanding of principles of equity and justice. It would be difficult to hold that an action which would be contrary to statute has the effect of violating others' fundamental right of equal opportunity of employment can be equitable and sympathetic though it is otherwise unconstitutional. A sympathy or equity which will result in upholding illegal and unconstitutional orders or acts cannot be considered to be within the four corners of principles of administration of justice in equitable exercise of power under Article 226 of the Constitution. It would be a travesty of justice if we allow the concept of sympathy or equity to influence the mind of the court even when the action is ex facie illegal and unconstitutional, violative of Article 16(1) of the Constitution. Recently, the Apex Court has declined to grant any relief to a person merely because it has worked for long time, though did not possess requisite qualification at the time of appointment in accordance with rules, and the appointment is not in accordance with the procedure prescribed. Now, coming to the third question, it is no doubt true that before passing the impugned resolution and giving effect thereto, no opportunity has been afforded to the petitioner by issuing a show cause notice, but the petitioner has been given extensive hearing before this court to show whether her appointment on the post of assistant teacher, junior high school, was valid, and the arguments at length have been heard. In view of the discussion made above, the only conclusion possible in the case in hand is that the appointment of the petitioner on the post of assistant teacher, junior high school, was in the teeth of the statutory rules and cannot be sustained.